Hello, everybody, and thank you so much for joining us for our webinar today. Our webinar, Divorce 101, the New Jersey divorce process. How do I start my divorce, and what should I expect? Now, first off, let's give you a little bit of a disclaimer. Please know that our presentation today is general information. It does not constitute legal advice. Be sure to direct specific questions about your case to an attorney. Now, there are certain stages to your divorce that we're going to talk about today. Stage 1 is beginning the divorce process. Stage 2 and 3, case management and discovery. Stage 4 and 5, early settlement panel and economic mediation. Stage 6 and 7, intensive settlement conference and trial. And then we'll talk to you about some post-divorce considerations. Questions and additional help will follow. Stage 1, beginning the divorce process. The typical New Jersey divorce begins when one spouse files their complaint for divorce. The complaint is the legal paperwork that you or your attorney give to the courts to start the divorce process. It tells the court the grounds for divorce, either no fault, such as irreconcilable differences, or fault, such as infidelity. Your papers must be filed in family court together with all the supporting documents that the rules require. Question: do I have to prove that my spouse did something wrong to get a divorce? And the answer is no. New Jersey permits no-fault divorces, or is a no-fault divorce state. Irreconcilable differences is the most common type of no-fault divorce here in New Jersey. Defined generally as the existence of significant differences between a married couple causing the breakdown of the marriage for a period of at least 6 months with no reasonable prospect of reconciliation. A note about private divorce mediation. If you and your spouse can come to an agreement, consider private divorce mediation as a way to resolve your case. One of you would still need to file for divorce, but some divorcing couples choose to attend mediation first. Mediation can certainly reduce costs. A divorce mediator does not represent either of you. Each of you may still need separate attorneys unless you choose to represent yourself. For more information, see our slideshow about this, Divorce Mediation 101. Back to your initial divorce papers, the complaint. We talked about that a little bit earlier. It's the paperwork that states facts and grounds for the divorce. The spouse filing the complaint becomes the plaintiff. Plaintiff receives the filed paperwork back from the court and then serves the spouse with the summons and complaint within 10 days. Plaintiff then files proof of service to say that the paperwork has been properly served. Now, the response to this can be an appearance, an answer, or an answer counterclaim. The responding spouse becomes the defendant, and upon receipt of the complaint and the summons, the defendant has 35 days to file an appearance or an answer, which may include a counterclaim. It doesn't have to. A special case, default judgments. If no response to the complaint is filed within the 35 days, the plaintiff can seek a default judgment. For example, you don't know where your spouse is living. You can't find him or her. This can also be an intentional strategy by agreement as a route to an uncontested divorce. Here's a little bit of a PDF or an example of the stage 1 of beginning the divorce process. If you want to take a look at that, it's a really good graphic about the steps that happen. You can certainly print this out and find this PDF on our website as well. So it's a pretty good guide for you to take a peek at here. Stage 2 and 3 is case management and discovery. Within 30 days of the last date for filing the answer to the complaint or the counterclaim, if any, the court will schedule a case management conference. That case management conference will fix deadlines for completion of discovery based on the number and the type of issues in your case, and it will also determine if any expert reports will be necessary for trial, such as a child custody expert or a financial expert, an accountant, say. For a complete description of stages 2 and 3, you could download our PDF and you can see that as well. A note about temporary motions. Do you need immediate help from the court? Well, you can file what's called a pendente lite motion for temporary relief at any time during the divorce case. Pendente lite is a fancy Latin term for in the meantime. And you could file for financial support like child or spousal support, or for a parenting schedule so that you can set up visitation or establish custody while the divorce is going on. Do you have a custody or parenting time dispute? The court will send most cases involving custody or parenting time issues to court-mandated parenting mediation, meaning you have to go. All cases involving parenting disputes are assigned to the priority track at the case management conference, and the judge will set a hearing date within 6 months of the answer to the complaint or the counterclaim. The court will require you to try to settle your parenting issues. They do that through court-ordered parenting classes. Parents propose parenting schedules to one another for the other to consider, and court-ordered mediation for disputes that the parents can't work out themselves. Question: what if you can't resolve your parenting issues through negotiation or mediation? Well, then the court will want an expert opinion, meaning that you will have to retain the services of a psychologist or a psychiatrist who's experienced in determining custody and parenting time matters. Custody investigations and evaluations can be done through the family division, where the judge can order social investigation, best interest investigations. They may include home inspections for shared parenting time to make sure the home is appropriate for parenting time. Could include psychological, psychiatric, parental functioning assessments or mental health evaluations if necessary. And the judge can also interview your child, but in chambers, not in open court. And as we said earlier, that can be private custody evaluations where parents can jointly hire a mental health expert to conduct the investigation and prepare the report, or parents can each hire their own expert. Child custody evaluators must be neutral and follow uniform standards regardless of who hires them. You may also need financial experts at trial if you're unable to settle your property or support issues. These issues can be dividing assets or debts, alimony, which is now more commonly known as spousal support, and child support. A few types of financial experts. We talked earlier about an accountant, but they could also be a financial advisor, a real estate appraiser, business appraiser, pension appraiser, or an actuary, or a vocational expert. For example, you believe your spouse is underemployed and you want to enlist the services of a job expert to testify about why they should be working. What is discovery? Well, discovery is when both spouses file and exchange the case information statement, which is required by the court, that details their financial information. And also, the court sets guidelines for additional types of discovery, such as interrogatories, notices to produce, and other sort of vehicles for gathering the information necessary to have a complete picture of the financial aspects of the marriage. So what does that case information statement include? Well, it's a financial inventory of the marriage. So it includes assets, expenses, income, as well as debts. Again, so there is a complete financial picture of the marriage. Additional discovery in a divorce case include document demands. Again, either party may ask the other for documents such as credit card statements, deeds, other title documents, etc. Interrogatories. Each party may send formal written questions to the other asking for information necessary to resolve their case. And depositions. Either party may ask the other party or other witnesses in the case to give testimony outside of court that will be transcribed by a court reporter. And here's our PDF about stages 2 and 3. As you can see, a pretty detailed flow chart again that you can check out on our website and download and have that as a guide for you. So let's talk about stages 4 and 5. That's early settlement panel and economic mediation. Now, I'm sure you know that trials are expensive and they're burdensome really for both parties and the courts. So New Jersey courts require most divorcing couples to participate in a series of court-mandated settlement efforts before going to trial. They are settlement negotiations, early settlement panel, and economic mediation. And again, you'll see at the end we have a PDF that describes stages 4 and 5 of the divorce process. So what is the early settlement panel? Well, the early settlement panel is 2 or 3 experienced volunteer family attorneys who review your issues and provide recommendations for resolution. If both of you decide to accept the panel's recommendations, you can go immediately to court to put your settlement terms right on the record. You'll be divorced that day. The judge will grant you your divorce before you leave the courthouse that same day. What is economic mediation? Well, if you do not resolve your financial issues after the early settlement panel, the court will then require you to choose an economic mediator to help you reach an agreement. And here you go. Here's our PDF regarding stages 4 and 5, early settlement and economic mediation. You can take a look at that on our website. Good flow chart there for you with all the information we talked about. And lastly, stage 6 and 7, the intensive settlement conference and trial. If you still cannot settle your financial issues after economic mediation, the court will ask you and your attorneys to attend an all-day settlement conference in a final attempt to avoid trial. If it still doesn't work and you go to trial for your divorce, the family court judge will review evidence and hear testimony from you, your spouse, your experts, and any other witnesses before ultimately making a final decision on all unresolved issues. Barring any appeals of the judge's decision, you will have a judgment of divorce with final orders after the trial. And here you go. Here's stages 6 and 7, our little flowchart that we put together for you. Intensive settlement conference and trial. You could see how that flows after the intensive settlement conference and what happens after trial. The New Jersey divorce process does not necessarily end with the final judgment of divorce. Sometimes there are post-divorce motions for enforcement. The majority of post-divorce issues occur when one party fails to carry out the terms of the final orders in the case. You can file a motion to enforce litigants' rights, asking the court to enforce existing orders for child custody, visitation, child support, or spousal support. Now, post-divorce modifications. Child custody and child support orders can be modified or changed until the children are emancipated, meaning that they're independent, they're no longer under the sphere of the parent's influence. Most alimony orders can also remain changeable under certain conditions. All modifications require a substantial change in circumstances in order for the judge to say, yes, there needs to be a change either in alimony, custody, or child support. If you have your own questions about what you saw today in our webinar, or perhaps other questions that we didn't cover, please give us a call at 888-888-0919. Email us at info@weinbergerlawgroup.com, or you can certainly always visit our website, www.weinbergerlawgroup.com, for more information. And of course, if you'd like to come in and talk with one of our attorneys, give us a buzz, 888-888-0919. Schedule your free confidential legal consultation to discuss your divorce in New Jersey or any other family law issue that you may be having. We hope you learned something today. We hope you enjoyed our webinar. Of course, like I said, if you need any further information, visit our website, give us a call, shoot us an email. We'll be happy to talk to you. Thanks again.